Here with reaction, former President Donald Trump's lawyer, attorney Joe Tacopina, is with us. Joe, let me go through this indictment with you because, you know, all 34 counts are pretty much the same, with the exception of where the funds come from. For example, I'll look at the first count. Grand jury, New York, by this indictment, accuses the defendant of a crime of falsifying business records in the first degree in violation of Penal Law 175.10, committed as follows. And then it says the defendant, in the county of New York and elsewhere, on or about February 14, 2017, with intent to defraud and intent to commit other crime and aid and conceal the commission thereof, made and caused a false entry in the business records of an enterprise, to wit, an invoice from Michael Cohen. Now, that's where it gets a little different. Can you explain to me what the intent to defraud, intent to commit another crime, what is that other crime, and to aid and conceal the commission thereof? Do you know what the hell they're talking about here?
Well, you know, normally, Sean, the indictment clears that up for you. When you get that indictment, it normally clears it up for you. Here, it didn't. It doesn't. It simply says that it's a false business record, as you cited properly what the indictment reads, for the attempt or intent to defraud or aid and abet the commission of a crime or to cover up another crime. Now, let's be clear. The first count is a misdemeanor without that added language about the other additional crime. It's a misdemeanor. Obviously, they couldn't bring a misdemeanor count anymore. Statute of limitations is long gone. So they cobbled together a few misdemeanors and called it a felony. The problem with that is, let's guess what they're talking about when they say another crime without identifying it in the indictment, which to me is striking. No, there's no legal requirement for them to do it, but it's standard operating procedure to do it. Anyway, that they must be talking about federal campaign election laws, because that's all there was, a federal campaign. It is clearly not a crime under FEC laws to settle a civil case, resolve that civil case with personal funds, and then not notify the FEC, even if you're in the middle of a campaign, because the rule is if that payment would have been made irrespective of the campaign, which here it clearly would have, that's why it was made with personal funds, there is no FEC obligation. That's what Bradley Smith, the former FEC chairman, has already said. So this indictment was a disappointment in one regard. In another regard, it was a relief because they didn't try and pull anything else. I just don't know how they think that square peg fits into that round hole. I saw Alvin Bragg on that commercial that you played, John, which is very powerful, and I assure you will be part of our motion to dismiss when we'll cite that commercial. When he's asked about, you know, going after Donald Trump, the question was not even an articulate question, is, are you going to convict Donald Trump? Well, before we get to the conviction, we have to get to the investigation, the charges, and then the conviction. But we went right to conviction, and Alvin Bragg didn't correct him. He said, that's priority or issue number one. Really? Right, so you weren't in office. You had no access to evidence.
Let me go through this indictment. Now, when they reference the payments, they're all in 2017. Am I reading that correctly? All 34 charges? I am correct on that, right? Okay, so when I have this letter...
Yeah, you know what he was doing in 2017, right?
Yeah, in other words, the payments they're alleging took place in 2017. Now, this is Michael Cohen's lawyer's letter to the FEC. And he's saying in February of 2018 that none of these things happened. So their star witness now, is he going to defend his own lawyer's words? Did his lawyer lie? Did Michael Cohen lie? I know he's an admitted serial liar. I know he's a convict. But do those dates match up to you? Is there an issue there in terms of they're saying the money was paid in 2017, and Michael Cohen's attorney is saying right here that nothing at all happened by 2018. Can you help me with that?
No, I can't. What I can help you with is none of it all matters. Yes, Michael Cohen is constitutionally incapable of telling the truth. He every day he switches a story from one to another to another. He just said, Sean, 4 days ago, that when he pled guilty in federal court, you know, now he's a new man, he has a new lawyer, and he's going anti-Trump now instead of pro-Trump, and all the things he swore to in the past are now not true. When he pled guilty in federal court, he just said a few days ago that he really wasn't guilty. He was forced to plead guilty to protect his family. Well, then he committed perjury. So let's add that. little act of dishonesty and felony to the litany of criminal conduct of Michael Cohen. But I can't help you with it because it doesn't make sense. But here's the kicker, Sean. You want to know the kicker? It doesn't matter. Even if Michael Cohen were telling the truth, and even a broken clock works twice a day, right? Even if he were telling the truth, it still doesn't amount to a crime because there is no FEC violation. And that is so vital in this case. There was no reporting obligation. You know what's really funny? When we talk about selective prosecution, Sean, this is very important. Most reporting violations of campaign finance law are almost always never prosecuted as felonies, almost always never. They're normally given fines. You want a great example? Hillary Clinton. Just recently, her campaign was given a fine for the campaign that Donald Trump's now indicted for the Steele dossier payments. Those were payments for, dirt digging. Okay, that falls squarely within campaign finance laws. The only purpose for those payments to get that dossier on the fake Trump-Russia stuff that he colluded with Russia, which proved to be a hoax. All of that was done with campaign funds. All of that was exclusively for the purpose of the campaign, unlike the personal resolution of a civil claim that Donald Trump did. Yet, they marked, you know what Hillary Clinton's campaign and Hillary Clinton marked those monies for? Legal fees. Legal fees.
Let me ask you
that's
then
a lie.
this.
And she was fined. She was fined, and he's indicted for a personal expenditure, which were for legal services.
Now, based on the fact that Alvin Bragg ran to go after Donald Trump, and he made that a campaign promise, would that be a motion possibility for recusal? Are you going to put forth a motion for a change of venue? Or are you going to put forward a motion about prosecutorial misconduct or selective prosecution, considering this has never happened? Last question.
Yes, we're going to put forth all sorts of motions. Look, we just got this indictment today. Doesn't really help us that much. We have a statement of facts. We're going to get some discovery and some evidence, and we have 4 months to make motions. But I will tell you, a motion to dismiss is coming on several grounds. Prosecutorial misconduct, selective prosecution, for sure will be 2 of them. Legal insufficiency is another one. But we have a clear case of selective prosecution. If this man's name was not President Donald J. Trump, he would not be prosecuted. We're looking at statute of limitations. There's a whole host of motions that's going to be, levied here. And I will tell you this case won't see a jury, in my opinion.
All right, Joe Tacopina, thank you.